Okay, hello everyone. Good evening. Can we all hear me? Hello, good evening. Can we all hear me?
Good evening, sir. Yes, we can. I can hear you, sir.
Good evening, sir.
Oh, all right. Thank you very much. Good evening, everyone, and welcome to class. Okay, good evening and welcome to class. Welcome to week 2 of the JIIPCC Mentorship and Internship program under data privacy and protection. We have quite a lot that is scheduled for today, so we'll not waste any time. I can see we already have our mentor on the call. I want to say a big thank you, Mark, for joining in on time. All right, I hope we have more mentees joining soon enough. We'll be in today's session. Our agenda for today would be we'll start off with introducing our mentor for today. We will then head to we will then head to mentees presentation. So we'll be having presentations from both group 1 and group 2. So please, I want to encourage both group. Okay, for those who are in the call, we'll be taking presentations from both groups. So please, immediately after we're done with introduction, group 1 will make their presentation, then group 2 will go ahead with their presentation as against what we did in the last class. So after that, we would be taking presentations and the discourse of, our mentor. And then after that, questions and answers, pictures, and then we'll call it a day. So please get ready for your presentation after we are done after I'm done introducing our mentor for today. So in today's class, our mentor for today is going to be Mrs. Mercy C. Matthew. Um, I will just read a bit of her profile, seeing that we already introduced her in the last class, but I'll just read a little bit of her profile just so that we can familiarize ourselves with her. Right, so Miss Mercy is an associate at Jackson Etty and Edu and a member of the firm Data Protection Practice, where she actively supports clients in navigating the evolving data privacy and compliance landscape. She has hands-on experience in conducting data protection compliance audits and delivering capacity building training sessions for companies across diverse sectors. She has contributed to numerous data audit exercises and developed remediation frameworks for both local and multinational companies. Her work spans advising on compliance with the Nigerian Data Protection Act and General Applications and Implementations Directive an implementations directive. So I will stop here in the introduction. We'll send out her flyer to the group so that you can still go through her profile if you haven't, and also if you would like to use her profile while making your post after this class, you can also do that. So what we'll be doing now, like I earlier said, is we'll be starting out straight out with presentations for mentees. So that's what we are going to be doing first. So group 1 and group 2, you have 15 minutes each for your presentation. So the presenter for group 1, if you are in session, kindly go ahead, share your slides, and then start your presentation. Like I said, we have 15 minutes each for presentation. So please, if the presenter is in class, you can go ahead and start. Do we have the presenter for group 1 in class? If the presenter is not available, can we have the backup presenter or any other person within the group who is familiar with the presentation and can stand in on behalf of the group? Can we all hear me? Please, hope I'm not speaking to myself. Can we hear me?
Go stop. Yes, we can.
All right. So if group 1 is not yet ready, I want to assume that they are still getting on board. Please, if group one is not ready, can we have the presenter for group two come on board and make presentations? We want to have good presentations in class. So please, if you are ready with your presentations, you made submissions for them. So we want to hear what you guys have done. So group two, please come up and make your presentation. After that, we'll go back to group one. Who is presenting on behalf of group two?
Hi, good afternoon. Sorry, it's evening already. Good evening. I'm the presenter for group two, but I'm unable to share my screen. Is it possible for you to assist with that?
All right, you have to give me a minute to do that. I'll have to download your slides. But you can give me a few seconds to do that. I'll try to put that through right now.
Okay, that's all right.
Why are you talking back?
Okay, give me a moment. It's up. Let me share it from my end. I've gotten your slides.
Okay. Hello, everyone. Good afternoon. So I'll be presenting on behalf of group two. I hope everyone can hear me.
Yes, we can hear you.
Yes, we
Okay,
can
but
hear
before
you. Okay, great.
can you hear me?
Sorry. Yeah, I can hear everyone down. No, thank you. So please handle my voice is very loud because maybe under the weather. So I am presenting on behalf of group two, and our topic for today is lawful basis for data processing and lawful data transfer. Please, you can move to the next slide. Hello, can you hear me? Mr. William? Oh, yes, thank you. So, we're starting with the lawful basis of data transfer and data processing, rather. So, per the Nigerian Data Protection Act, Section 25, we have six, if I remember correctly, we have six bases for processing of data. So, the first lawful basis is consent. That is when you consent that this company or this person can process your data. So consent is mostly given, say you want to use a website or an app, we always see the privacy policy that pops up. When you click, yes, I agree to this, so and so terms and conditions, you've given consent. So that's why it's very, very good if you can look through it and see what you are consenting to. So you cannot hold them on any grounds of breach when you have consented to whatever is in the privacy policy. And consent has to be clear, it has to be willing, it has to be informed. And another lawful basis is contract. So if there's an agreement that, oh, this is how I'm going to process your data. There's sorry, there's a contract between you and your data processor. That's another lawful basis. Where it's required by law, your data can be processed as well. There's vital interest, there's public interest, and there's also legitimate interest. So please move to the next slide. So we have a bunch of cases here that shows how the Nigerian courts have applied these data processing principles per the Data Protection Act. I'll just take one. You can look through it and look at the other cases because they are a bunch. So in what happened in Godfrey, I think. Okay. We have, okay, please let me start with Araka. So here, oh, Jesus, I'm so sorry. I can't see the screen again. I can see it. We have Araka and ECAT. Please go to next slide. I'm only taking one. We have Godfrey, Enaya, and MTN Nigeria. So what had happened in this case was MTN had breached the customer's privacy by disclosing their number. And because MTN had disclosed their number, they got unsolicited messages. The Court of Appeal held that there was a breach of privacy, and this is a reinforcement of the NDPA's stance on protecting data subjects. Please, the next slide. Same thing here, digital right lawyers versus IT solutions. So 200, in this case, 200 million emails were advertised for sale. And this was, sorry, excuse me. Sorry, I'm a bit under the weather, that's why. So here, 200 email addresses were advertised for sale. And this case highlighted gaps before the NDPA 2023 was enacted. Please move to the next slide. So data transfer, the meaning of lawful data transfer. Data transfer refers to the movement of personal data from one entity to another, whether it's within the same organization or across borders. For example, transferring data from one system to another, from one country to another, or from one individual to another. We all transfer data one way or another. Data is always moving. It can be moved within organizations. It can be moved from individual to individual. It can be moved from individual to organization. It can be moved from one country to another. There are various ways whereby data is transferred. Next slide, please. I can't see your screen. Should I still sharing?
All right, sorry about that. It seems part of your slides weren't showing, so let me try to share.
Okay. So, okay.
There's something wrong with your slides. There's something wrong with your slides. These are cut out, so I can't really see. Like,
Okay,
it's
so I'll
not.
just let me open it on my end. I won't be able to share though because I'm not using my laptop, so and my phone has issues with sharing. So apologies for that. So we have types of data transfer. Is it possible? Is that visible on the slide?
No, it's not.
Okay, so data can be transferred there are 4 types of data transfer. We have the internal data transfer, external data transfer, international data transfer, and cloud-based data transfer. Just like the name implies, international data transfer is basically when data is being transferred within the same organization or within the same system. And then for external transfer is when data is being transferred from an organization to a third party organization or to another individual. And then international data transfer is when this is cross-border data transfer, when you're transferring data, say, from Nigeria to the US, from Nigeria to whatever country. And then we have the cloud-based data transfer, which is transferring of data to a cloud-based storage system. I think you should be able to move to another slide now. I've taken the blank slides.
All right,
Okay.
I've changed it. Yeah. Please, you can go ahead. I've changed the slides.
Okay. So cross-border transfers falls under section 41 to 43 of the NDPA. I can't see your slides anymore. It's loading. Let me just go ahead with on my own. If you can change it as I speak, that would be good, but I can't really see it.
Oh, okay. Please go ahead. It's showing on my own end, so please just go ahead.
Okay, so we have lawful data transfer. To ensure the best practices and compliance with the NDPA when it comes to the transfer of data, the following must be complied with. So these are set down rules in the NDPA before data can be transferred. For a data transfer to be lawful, these are the practices. You have number 1, the data subject must consent to the transfer. Number 2, the transfer is necessary for reasons of public interest. The data transfer method must be secure. The data transfer agreements are in place and they must comply with data protection laws. So if you remember when I spoke about lawful basis of data transfer, this is just like an explanation for it. This adds to it, right? So that's it. And then we have cross-border transfers. That's transferring data across borders, which comes under section 41 to 43 of the data NDP, Nigerian Data Protection Act. So the default law is that it is absolutely prohibited transferring data abroad, but it is allowed when there's adequate protection or where this data subject consents to it, there's a contract in place, public interest and the rest. Again, back to the lawful basis of data transfer. I can see your screen now. Please, you can switch to the next slide. Okay, so per the last slide, we said that data transfer abroad is prohibited, but is allowed if there's adequate protection. So there's a test for adequacy, which is under the section 42. The data transfer, cross-border transfer is adequate where there are strong data laws in receiving country. That is the country that the data is being transferred to. So if the country that is receiving the data, there are no proper data laws in place, it's not allowed, it's prohibited. If rights and redress mechanisms exist, that is, if the data subject gets their privacy breached, the receiving country, do they have proper systems that allow the data subject to address their rights that have been breached and seek redress and obviously compensation and the rest, if they are independent regulators, and if the receiving country as well has international commitments. So that's probably like international treaties that multiple countries must have signed to And that's it. Please, the next slide. Again, this is the exception to the rule that there's no data transfer allowed across the borders. Again, it's allowed where there's informed consent, where there are contracts in place. Just again, the lawful basis. If you remember the lawful basis that we spoke about for data processing, this also applies under data transfer. Next slide, please. So why this law on data transfer, cross-border transfers is important is because obviously it protects our data abroad. So we're not worried that, okay, if my data crosses to seas now, that's it, my rights don't exist anymore. Anybody can do whatsoever with my data. Fraud exists everywhere. So it's important that we are sure that wherever our data goes, we can be secure. And also it ensures that businesses are held accountable, and it prevents weaker protections overseas. That is, the receiving country is aware that we require this data to be well protected, so they will ensure that the data is protected. Please move to the next slide. These are just examples of international data transfers. So you have Paris customer to Ohio server, Berlin SaaS to Singapore, Dublin employee to Brazil. And the key issue here, obviously, is that personal data is leaving its jurisdiction. It's moving from Berlin to Singapore. So because of that, there are issues with compliance. And that's why it's important that we have all these data transfer laws in place. Next slide, please. Why cross-border transfers matter? They matter because we would definitely always need to send data across to other countries, especially countries where, you know, there's a huge risk of your security being breached and all that. So that's it. So when your data is going to, no matter what country really, breach happens everywhere. So sorry, excuse me. Sorry for the break. Again, I'm not really in the best of health. But so I'll just quickly round up and get to the conclusion of things. So the best practices, right? The best practices for data processing and data transfer is that we need to know the lawful basis, right? And we should use contracts and safeguards, and the data subjects should always be informed. So these organizations, they have, and companies, whatever, they have a duty to inform you as the data subject. So you as the data subject, you are obligated rather to be informed. Like I mentioned, privacy policies. A lot of us, I am guilty as well, do not read through them. We just see them and quickly rush to, oh, I agree to the terms and conditions. And if you look at it, you know, there's like 20 pages of what you don't know there, and you just agree and consent. And when your data, you think your data has been breached, right? They will just come and show you that, look, you consented to this. This is in paragraph so and so of a privacy policy. So whilst they're informing us, we too should do well to be informed. And the organization should also ensure that data is encrypted and stored on secure platforms as well. And yeah, so that's it for us. Thank you very much.
All right, thank you very much, Oge, for presenting on behalf of your team. All right, we're able to receive the presentation from your group. So well done to you and to your group members for putting together that presentation. So please, can we have group one make their presentation now? We'd like to wrap up with presentations quickly so that we can have our mentors discuss. is a group presenter for group
Okay.
one ready now?
Dennis, I'm so sorry to butt in. I wanted to, just so that I don't forget, I wanted to ask some questions on Group 2's presentation and maybe clarification on some slides before we move on to Group 2. I don't know if that's okay. So that after
That,
then we'll just now do a general discussion.
all right, that's fine, ma'am.
Okay, thank you so much. Thank you very much. I didn't get the name of the presenter for Group 2, so sorry. Please tell me your name again.
Hello, my name is Ogi.
Your name is?
Hello, can you hear me? Ogi.
I don't know if it's my internet. Your name is what? I didn't get that, sorry.
Ogi, like Ogechi. Ogi.
Ogechi, okay, thank you. Okay, I wanted to confirm the slide on types of data transfer. Can you clarify or let me know your authority? I'm coming. Your authority for the categorization that you give. I'm particularly interested in the internal data transfer. Good evening.
So how the slides were made is people drop contributions, and this is obviously from research. So this is most likely from someone's research, and that's how we got it. I'm not sure there's a particular authority on it. If it's not included,
can any of the team members speak to it before I make a comment on that?
please, from Group 2, does anyone want to speak on the authority for types of data transfer? I don't think that we have an authority for that. It's just based off on research.
Okay, so I'll just quickly comment so it doesn't skip my mind. When we speak about data transfer, really we are speaking as to entity, right? If it is within a particular organization, we may not refer to it as transfer. Do you understand? Transfer is when data is moving from the hand of one entity to another. So usually when it comes to data protection, the terms we will use will then be maybe if data is being transferred from data controller to data controller or data controller to data processor, that kind of thing. Do you understand? So, yeah, for the purpose of your research, I understand if you include internal data as part of your transfer. But if I'm receiving personal information from a data subject, do you understand? And that entity is getting the consent of the data subject to process their personal information, then it would not be, how do I explain this? Please let me close it down. If an entity has gotten consent, right, I do not need to go back to the data subject to get consent again to transfer personal information from my front desk to HR unit. Do you understand? Because in that sense, or from IT to HR or from HR to IT, because in that sense, I will now be getting consent over and over and over, which is not the goal of the law. But what the law is trying to do is that once data is leaving an entity, whether you are a data controller, a data processor, whether an entity or an individual, right? But that's why I'm using the language data controller, because remember in our last class, we said data controller can be either an individual or an entity. Once data is moving from a controller to another controller, or from a controller to a processor, then we can say that data is being transferred. I don't know if that is clear. So internally, personal data would be transferred for administrative purposes, right? But not that data is now moving from a processor to an end to a controller or a controller to a processor, right? This would also apply because I see your question at the end of your slide. If it is moving from a group company to a subsidiary, we would refer to that as a transfer. Because those are, if of course, in the eyes of the law, those are two separate entities, even though related. It's like saying a brother and a sister. They are not one person. They are two people under the same family, but they are two different individuals. Do you see? So if data is moving from a company to its subsidiary, that's a data transfer. So in practice, what we usually do is to ensure that they have what we call an intra-group data processing agreement that allows, that group of company to share data within all of their subsidiaries. I don't know if that point is clear, right? So just for the purpose of that, external data transfer, that's a given. International, that's a given as well. But we will not typically refer to the internal movement of personal information as data transfer, because in that instance, you may not need to get consent. Do you understand? By the time you're getting consent, the initial consent, you should have specified all the things that institution or that data controller processor will be doing with personal information. It should include, of course, the fact that it will go to IT, the fact that different units will process personal information for the purpose of either fulfilling a contract or whatever it is they are getting into. Let me know if this is clear. I just thought to clarify that so that I don't forget.
So you're saying that when we're talking about data transfer under the within the ambit of the NDPA, internal data transfer doesn't fall under. It doesn't cover that. It's not necessary.
It doesn't envisage it. Yes. In essence, what the law would envisage is movement of data from a controller to another controller, or a processor, a controller to a processor, or a processor to another processor. But it is just moving from one body, one entity to another, whether an individual organization. Is just moving from one entity to another, not internally.
Okay. That's very clear. Thank you very much.
Okay, hold on. I want to speak to when this matters. Okay, the slide on international data transfers, I wasn't so sure like what you wanted to address. You just put some points, but you didn't really speak to international data transfers on that particular slide. So I wanted you to touch on it a bit. I reckon that maybe for time's sake you glossed over most of the last slides, but the slides particularly titled international data transfers, if you can speak to it a bit, I would appreciate maybe in 1-2 minutes. Or anyone within the team.
Hello. Hello, can you still hear me, please?
Yes, we can hear you, okay.
Okay, please, I didn't really hear you. You said, I should speak on this slide. What? The slide on international data transfer.
Yes, Miss Mercy asked that you speak on that she didn't really get your discourse on international data transfer. So if you can, in a minute or two, speak on it, that she would appreciate.
Oh, okay. So for international data transfer, I don't think I really said so much. I just gave the examples, which was Paris to Berlin and the rest. I just gave examples of moving data internationally because that's what I know about it. So that's what I shared.
Okay, so please, do we have anyone within Group 2 that may want to speak more or give more light to international data transfer as based off of what you guys researched in your group? Do we have anyone in Group 2 who would want to speak to these slides?
No, we can move on to the second group.
All right, thank you, Ma. So please, can we have the Group 1 presenter for Group 1? If you can please come up, share your slides, and start your presentation.
Good evening, everyone. I don't know if you can hear me.
Yes, good evening. We can hear you. Juliana.
I am Bright and I'm the presenter for Group 1. I want to share a slide now. Just give me a minute. Let me share our slide.
All right, Juliana, is your slide up or do you need help with that?
Please, I will need help because I'm trying to share from my hand and it's not working. I don't know why.
Just give me a minute.
Okay.
Sorry everyone. Sorry it's taking time. I'm coming. I will be sharing right about now. All right, can you see my screen?
Yeah, I can.
All
Okay. I'm Bright Juliana. I'm presenter for Group 1. I'm going to present data transfer best practices.
Sorry, Juliana, your voice is not very clear. Please, can you maybe move from where you are to maybe a place with a little bit less noise so that we can hear you clearly?
Can you hear me now?
Yes, much better.
Okay. Please, can we move to the next slide? So I'm going to start with definition of terms of what is data collection. Or let me just run down. Yeah, slide 1 is data collection, slide 2 data processing. Then we have slide 3 that talks about data manipulation. Then slide 4 talks about types of data, like 5 sensitive level and 5. Next. Those are there. Can you hear me?
Okay, your voice is breaking. I can't really hear you clearly, but I can hear you now.
Okay. So I'll start with the definition of data. So data collection is involves the thematic process of data, data, various it's data process. Collection for specific things. So that's just the next slide. Data processing or it's involved
Sorry. Hello, Mercy. Hello, Juliana. I mean, can you hear us?
I can. Can you hear me?
Yeah, yes. Your voice is breaking. It seems, I don't know if it's your location or if
Okay.
it's the network.
Can I join? Let me try and log in. Let me try.
All right, so please, can you do that in like
Yeah,
very quick?
let me do that now.
All right, thank you. Okay, Juliana, are you back with us? So you said?
I'm trying to join from a laptop. Just give me. Let me watch it.
Um, we don't want to waste so much time waiting, right? So please, if you can still just try once more, right? So that we don't spend so much time just waiting for you. Juliana, are you with us?
I'm in now. I don't know why you can't hear me.
Oh, okay. You were not speaking. Your voice speaker was unmuted, but please go ahead.
Okay, let me look.
Hello, Juliana, can you hear us? I can see your mic is unmuted, but I can't hear you. I can't hear you at all. Okay. She still seems to be having some challenges with her network. So please, can we have someone else from group one step in to present on her behalf? Then once she's able to sort that out, then she can take over. Do we have someone else in group one that can do that so that we don't spend all day just waiting for her to present? Do we have participants in class? I noticed we are a bit cold today. Please, can we respond? Okay, you seem to be back. We can hear you.
Can you hear me now?
Yes, we can hear you. Please go ahead.
Okay. Thank you. So please, I'm so sorry. I think I was having issues with my phone. So I think I have to start from the definition of terms again. So I'm currently at data processing, and data processing simply means or refers to the process or act of transforming raw data or unused data into meaningful and more organized information. It involves a wide range of actions such as data collection, recording, and the rest. Then the NDPA, specifically in section 24, provides for principles for data processing, and there are quite a number. I will just list and explain some. So one of the principles that it must be lawful, it must be transparent, and let me just read directly from the acts if time permits. That before the data will be processed, it must be fair, lawful, and in a transparent manner. And the data must be collected for a specified or legitimate purpose. So you can't just collect data randomly without having a specified or legitimate purpose to or use of that data. So that's just one of the principles that we are going to look at. And also one of the principles again listed here is that it must be adequate, relevant, and limited to the minimum necessary for the purpose for which the personal data is collected from. So just like I said, it must be relevant. You cannot just randomly collect data without a specified purpose, without having a use of it. So that's one of the principle as well of data processing. Please, can we move to the next slide? So I will talk about now one of the bases for data processing. Why do we need, what basis should we process data? So section 25 of the NDPA, I guess some of us know what NDPA, so I'm just going to abbreviate a lot, specifies the lawful basis in which we can collect, like we can, for data processing. And one of them is it must be in it must be used for it must not be given without a lawful consent. Like people must consent to their data is being processed or used, and it must also be necessary. The processing must be necessary. It's not like, just like I said earlier, it's not something you just do out of random. And also it must be within legal obligations. It must also be via contract and all. So those are all one of the lawful bases in which data can be processed. And also for legitimate interest. I'm just kind of rushed because I think I've spent so much time, so I won't really explain everything in detail. Next slide, please. So one of the case study is this case of Nigeria Data Protection Commission and Fidelity Bank, where Fidelity Bank violated the NDPA by processing personal data without lawful basis and without informed consent. So there was no consent from the parties involved, and they still went ahead and processed data. So the NDPC investigated and revealed that the bank didn't comply to the data processing tools and that is being specified in the act. So they were fine actually at the end of the entire matter. Next slide, please. So we'll now talk about data minimization. Next slide, please. So I can pull up. Okay. So data minimization is provided under section 24 sub 1C of the NDPA. And this requires organizations to collect, store, and process only the minimum personal data necessary. So there are specific data for different purposes. So what this data minimization is just saying in detail is that you are to collect the data according to that particular purpose or that you want to use it for. For example, if it's something about health that you're taking data for, it should be data collected for the use for health only, not going ahead and collecting data for other purposes. So it's more like it reduces the risk of other personal information going out when you just stick to the particular purpose which you need the data for. Next slide, please. So reasons why data minimization is important is one, to enhance privacy. Just like I said, there are people information, they are not just random information. So it's with the data minimization, it helps to protect people private information just being out there. It also reduces storage costs and it makes it even more efficient when you just take the particular data that you need and not going all over the place. And it also ensures compliance. Next slide, please. So under the NDPA, there are different principles for data minimization, such as adequacy, relevance, necessity, limitation of data retention, restriction of data access, and the rest. Next slide, please. So now we are going to talk about types of data. So yeah, the types of data recognized by the Nigerian Data Protection Act are general personal data, which include basic information such as names, phone number, addresses, just basic information about people. That's what personal data, general personal data is. And this general personal data poses lower risk. Even if it goes out there, the risks are kind of limited compared to other types of data. Next slide, please. So there are also another category of data called sensitive personal data. So these are a little bit more personal, and such as your health information, your biometric, your financial data, and the rest. So these are a little bit more sensitive because a lot of people won't want most of this kind of data to just be out there. For example, now your financial data, just imagine your data about your finances just out there. Like it poses more security threats and the rest. Next slide, please. So there's another category that talks about certain types of data that require more protection or heightened protection due to their sensitive nature. Just like I said, financial data, your banking information, your credit histories, these are kind of very, very sensitive data that shouldn't just be out there. Also, your health data, your medical records, your insurance information, health-related personal data, also your biometric data like fingerprints. Just imagine everybody having access to your fingerprints, facial recognition, and it poses more risk of security. And this type of data require more protection due to their sensitive nature. Next slide, please. So I will talk about the sensitivity level of data. Next slide, please. So sensitive level definition is that it refers to data that must be strictly protected, just like what I said about the financial data, your biometrics and all. Those fall under the category of sensitive level data that they need to be more protected, and they cannot just be used without adequate authorization from the individuals or organizations. And Section 65 of the NDP defines sensitive personal data to include generic and biometric data, which I've said before, race, ethnic origin, religious, health status, political opinions, and the rest. So there are lots of data that can be classified under this sensitive personal data. Next slide, please. So Section 30 of the NDPA prohibits processing of certain kind of sensitive personal data, except these data are used for lawful grounds, such as the data subject valid consent. It's not just, it's somebody actually consented to this sensitive data being put out there. So it's not done without consent. And also compliance with employment, social security, or similar laws. Then legal claims, legal advice or proceedings, vital interests of the data subject, if it's for medical, welfare, or public health purposes, and under strict safeguards. So under all these are particularly like lawful grounds in which this sensitive personal data can be processed. Next slide, please. So when processing these sensitive personal data, there are certain rules which one has to consider, which is one, risk of harm. How badly, if you misuse this data, what will be the adverse effect of it? Then expectation of confidentiality, whether people will naturally expect that the data should remain private or not. Then adequacy of protection, whether existing safeguards are sufficient. So before you process, I think there are safeguards that the organization or whoever that wants to process data has to put in place. So you would try and consider if those safeguards are sufficient enough before processing such sensitive data. Next slide, please. I think the next subtopic is data transfer. So data transfer simply means or occurs when a data controller or a data collector transfer data from one location to another. And this particular section 41 and to 43 of the NDPA Act covers the entire data transfer symbol. For these purposes, we will focus on just cross-border data transfer. Next slide, please. So cross-border transfer simply means transferring data from one jurisdiction to another, or movement of data from a particular location to another. Next slide, please. So Section 41 of the NDPA provides basics for data transfer in the country, and there are certain prohibitions that the Act also provides that before a data is being transferred from, for example, Nigeria to other jurisdictions, there are certain grounds that or rules which must be complied with. One is that the data recipient is not subject to any law, corporate rules, code of conduct, or other personal information that are not in line with the provision of NDP. That means before this data can be transferred to other jurisdictions, it must be in line with the provisions of the NDPA. That is why the Act is there. It must not be done randomly. They all have to be in line with the provisions specified in the NDPA. And also, Section 42 for that lists certain conditions. And it's only when the other jurisdiction meets these conditions that data can be successfully transferred from Nigeria to other jurisdiction. Next slide, please. Just like I said, according to, and these grounds, they're also further expanded in the general application and the, implementation directives. They also state other grounds in which you can transfer data from Nigeria to other jurisdictions. Next slide, please. So I think these are just the grounds. I don't think I should go over all this because of time. I think I've spent so much time. Next slide, please. So just some of the grounds are availability of data, subject rights, existence of an instrument between the Commission and the data protection body in the recipient country, and the rest. Next slide, please. So access of public authority, all these are just some of the grounds that are involved in data transfer. So section 42 of the NDPA also gives the commission certain powers in assessing the adequacy of the present country. So before this data is being transferred from Nigeria to other jurisdiction, the NDPA also has a power to look at some of the issues of guidelines for assessments of the recipient country, then approval of corporate rules and contractual clauses for data transfer that are in line with data protections under the NDPA, and a whole lot of other powers that are being vested on the Nigerian Data Protection Commission. Next slide, please. So section 42 also provides for other grounds for assessing the adequacy of the data protection in the recipient country. So all these, basically from 41 to 42, just list out the grounds in which the country which the data is being transferred to has to comply with. Next slide, please. Okay, just like I said about this Schedule 5 of the General Application and Implementation Directive, which also lists further grounds for data transfer, such as cross-border data transfer instruments that must be approved by the Commission and other lawful basis. So you have to consider all these grounds before data is being transferred from Nigeria to other jurisdiction. Next slide, please. And next slide, I think I've laid more foundation about this. So basically, I think one thing we need to take home from there is that one, our data are really important, from our personal data to our sensitive data. And before these data are being transferred, there's actually laws in place that one has to consider before transferring data, or rather processing data as well. So I think I've come to the conclusion of my presentation. I think I've spent so much time. Thank you, everyone.
All right, thank you, Juliana, for your presentation. We apologize on behalf of the class that we spend so much time on presentation. Please, we would like to kindly ask for the two groups that let's try to see how best we can make sure to be in class on time, so that when it's time to make presentations, you are on board and you can do your presentations as well do. So thank you so much, Group 1 and Group 2, for making your presentations on the topic for today, data collection, processing, and transfer. So we'll be heading over back to Miss Mercy, if she's still with us, Miss Mercy, if she's still with us, to get her discourse for today and what she would like to share with us as regards our topic, and also other corrections that she would like to make as to the presentations that was made by Group 1 and 2.
Okay, thank you so much, Dennis. Good evening, everyone. Confirm that you can hear me clearly.
Yes, good evening, Ma. We can hear you.
Okay, thank you. I'm physically clapping for both groups. You guys have done amazing. Once again, I'm also let me also say how happy I am to see the level of research, dexterity that went into preparing your slides, and I love that, even without being tutored or guided through this, you're able to find all of this out by virtue of research, doing proper work, doing thorough work. And I love the level of understanding that I'm seeing that is, being passed across in the presentation. A nice one, you guys. Just running through Group 1's slide again I think I had something I wanted to confirm, but if it comes up in the course of I wanted to mention something on sensitive personal information. I will ask the group to go back and confirm. So I think that per Nigerian law, right, under the NDPA, financial data is not immediately categorized as sensitive personal information. right? You can confirm that from the the NDPA, the definition section, right? It doesn't exactly mention financial information as sensitive personal information, even though I reckon that I think it's under the GDPR and under certain jurisdictions refer to financial information as sensitive. So you want to be able to make that distinction whenever you're making a presentation. Do you get it? Because we are looking at what our local laws provide, being that we are in Nigeria, we are analyzing Nigerian laws, and then what international laws then provide. Do you see? So you want to make that clarification as well. So go back, do your confirmation, and then maybe by the next class, or if it's even something you're able to confirm for me here, you can do that before the end of this class. Check the NDPA, confirm that financial information is not immediately, and I say immediately, it's not immediately categorized as sensitive personal information. And I say immediately because, the law in that definition, it now says, and any other kind of information or personal data which the commission will prescribe as sensitive. So until we get a notice that the commission has now prescribed financial data as sensitive personal information, before it would then be categorized as such. But in the meantime, let me know that my understanding is correct. So if the group can immediately do that and then get back to us before the end of this class, I'll be wrapping up in 10 minutes. So yes, I'm happy you guys spoke before I did. So basically, I'm just going to touch up. Your understanding of data collection is correct, like we identified in our last class, and I see how that the last class really flows and ties into this week's course of this week's topic of study. When it comes to data collection, of course, it has to be done with the proper lawful basis, right? It's either you've obtained consent or for performance of contract and all the other principles or all the other bases of lawful processing that we identify today. Then once we have established, once the data controller processor has established lawful basis for processing data, then you can proceed to collect, right? And then also note now what you'll now be looking at is what are the best practices for collecting data. As you've identified here, consent has to be willful, clear, has to be unambiguous. Where the other lawful bases are also in place, what best practices do you now want to use? You want to ensure that your means of collecting your data collection channels or tools are embedded with your data privacy notices, right? You want to ensure they have the data privacy notices. You want to ensure that you're using secure means or secure measures for collecting personal information. So you don't want to be collecting personal information on something that is flimsy, right? I know that a couple of organizations still do. Okay, forgive the word flimsy because flimsy might paint a wrong picture. What I mean is you don't want to be collecting personal information on through a channel or through a means that can be subject to easy compromise. Juicy. So if you are collecting data on a digital device or a digital platform, you want to confirm how many people have access to this platform. How many people can access this personal information? The app, is it something that people can easily hack? Is it secure? What are the security measures? What are the privacy measures built into the app or built into the design of the app or the digital platform through which you're collecting such information? Juicy. That's what you want to be sure of, who and who has access. Is it just the IT unit of the organization? Is it, named personnel? Is there restricted access? Those are things you are now trying to find out. And also your data collection channel, is there what we call data privacy notice? That is, if someone is submitting, if a data subject is submitting their personal information through this channel, is there a notice that tells them how their data will be processed? Is there a privacy notice or a consent notice that then says, if you are submitting your information through this channel, please note that your personal information will be processed in accordance with our privacy policy, GUC. So a good data collection channel or means or tool, right, should have a privacy notice or a link to the privacy notice embedded in that data collection tool, just to make it easy for the data subject to refer to the privacy policy to now have a fuller understanding of how the organization, whether controller or processor is handling their information. Whether the company now intends to share with a third party, all of that will be embedded in the privacy, the fuller privacy policy. You get, if they're going to be sharing with third parties, if they're going to be collecting your information from third parties, they need to know all of that. Do you understand? Also, we need to something we didn't touch on in the presentations or how is data collected. Data can be collected directly from the data subjects, right? Data can also be collected indirectly. These days we have background check apps. We have applications that do background checks. And the legality of some of those things are still in question, because you just put somebody's name, email, phone number, and then it pulls up a lot of information about you, your educational background, this one, that one. I don't know, maybe some of you have used it before. I haven't, right? I haven't, because I'm really privacy conscious, and I don't even want to see what it can bring up, except it's my own information I'm trying to now see. Do you get? So people can get your information from different channels. The information you make publicly available on social media, that's a means of getting personal information on an individual. So you need to understand that there are different ways of collecting information. In certain instances, you're collecting directly from the data subjects. What you will not be looking at, what are the implications? That's what we're talking about: consent, performance of contract, and in other situations where you're not now collecting directly from the data subjects, you also need to be able to establish lawful basis. For example, next of kin information. Let me throw it open. What is the lawful basis for collecting next of kin information? Anybody, you can unmute and answer. What's the lawful basis for collecting next of kin information, or guarantor information, or referee information?
There must be consent from the individual, from the next of kin.
So
Must
who
be a
is obtaining the consent?
The person that is putting the name of the next of kin. That is, let me say, for example, me now, I want to use my brother as the next of kin. I have to first of all get a consent from him before I'll give it to whoever I'm going to use the information to.
Great. Thank you. That's one. What's the second one? What's another one? What's another one?
There must be a legal obligation, like binding the both of us.
Great. Thank you, Anita. Yeah, those are two important lawful bases for collecting next of kin or third party information, right? Where the law, that one is very key. There are certain instances, for example, your banking information. I'm sure they have guidelines that mandate them to collect next of kin information, so that if anything happens to the owner of such account, someone who is a next of kin or in the position of an executor, executrix, can then lay claims to what they have. Do you see? That's where the law provides. In certain instances, the law requires an organization to collect next of kin information. But you see how that goes hand in hand, just like Anita has identified, with consent. You, the person that is now providing the third party information, needs to obtain the consent of the third party to provide their information to the data controller or processor. Now, in that instance, we have what we call a third-party consent notice that should be included on your data collection forms, which basically is stated that if I'm the one, for example, I'm providing Genesis information as a third party, a next of kin, or a guarantor, or something of that nature, right? Or for example, I'm trying to apply for something. I'm saying, I've been a mentor at JIIPCC, and I'm saying, okay, Dennis will be able to referee me, that kind of thing. I have obtained Dennis's consent. So the organization getting the information from me should have something in their form that says, where you provide third-party information, you confirm that you have obtained the consent of the third party to provide their personal information to us. And we confirm that this personal information will be processed in accordance with our privacy policy. Do you see? That's what we call a third-party consent notice. In essence, we are saying that this third party has given their consent to the person providing their information for the information to be provided, right? While some may argue that that's not direct consent, yes, but what it does is that it absolves this company of liability. Where the law mandates them to collect such information, they can say, oh, we couldn't reach this person directly. You get, because in some instances it is impracticable to reach them or obtain their consent directly. But then ahead, they're able to now say, we got the information from this person who we had asked to make sure he obtains their consent, and he has confirmed that he has obtained their consent before providing such information. You see, so those are the things you need to look at when it comes to data collection, right? Then I will just touch on cross-border transfer because every other thing I see a good understanding of it. I also appreciate the understanding of cross-border transfer because it's really it's apt, it's in-depth and very clear. The points were passed across very clear. So yes, basically NDPA says no cross-border transfer. That's general rule. It now says except you have obtained consent or the other requirements in section 42 have now been 43 have now been provided for, which is where you now have okay, sorry, I'm mixing it up. No, the law says no cross-border transfer except a country has adequate privacy law, data protection laws, which you can then see by virtue of either their certification mechanisms, a data protection law, binding corporate rules, codes, and etc. Right? Then, if that is not available, then the provisions of Section 43 will then apply, which is where you have consent that has not been withdrawn, not just informed consent, not just explicit consent, but you have to make sure that the consent that was given has not been withdrawn by the data subject. And then all the other ones which we have identified, in the course of our discussion, right? So those are what the law provides. Now, you need to also, when you're doing your research, right, from probably the next class. I don't know if I'll be the one available then, but maybe by week 4 or so. Here, I also want to see you reflect in your research the provisions of the guide, NDPA guide. That is the General Application and Implementation Directive, right? I want to see that you have researched that as well, because what the guide now does, NDPA guide, which was released in March 2025 this year, we identified that as part of the legal framework for data protection in Nigeria last week, right? What the guide does is it expands the provisions of the NDPU. So now these sections 41 and 43 that we are looking at have been further expanded, especially this issue on adequacy. Guide now tells you these are the things we'll look at when determining whether a country, the receiving country, has adequate data protection law. Do you understand? So you now need to go and look at those items. Do they have certification mechanisms? Is there adequacy decision by the NDPC? Do they have what's this thing called? Cross-border data transfer instrument? Do you see? Then do they have an equivalent? Do they have a data protection authority, regulatory authority, the way we have our NDPC? Do they have the equivalent of NDPC in that country? Those are some of the things they will look at before the NDPC can then make an adequacy decision on a particular country. Do you understand? Then it now looks at other things, cross-border data transfer instrument, and what's this other one? There's a third one, other basis in here. So there's adequacy, there's CBDTI, which is cross-border data transfer, and then other basis, which is where all these other things under section 43 will now feature. Do you understand? So I need to see that the provisions of the guide also reflected in our research is very important. So you want to look at, I think it's Schedule 5 of the guide that provides on cross-border data transfer. Very elaborate provisions it makes there. So you need to also go and read that up to have a proper understanding of cross-border transfer and the requirements. Yes. I think this is where I'll be stopping for now. Let me know if you have any questions or if you need further clarity on anything that I've said.
All right, thank you very much, Mrs. Messi, for your very detailed both your very detailed take and some of the things you've highlighted. So we'll be taking I want us to do something before we take questions. Right, it's getting pretty dark at my own location. So please, if we can we turn on our videos for pictures and then we'll go straight to questions. So please, if you're in class and you can turn on your videos, please do so that we can take a quick picture and then, we'll get back to questions. All right, please, do we have mentees in class? Thank you so much, everyone. Thank you, Habib. Thank you, Isusa. Thank you, Joy. All right, so we have more people turning on their videos. All right, we are done with that. Thank you, everyone. So please, we would want to take questions in class. So, it has been quite an interesting discourse. And from Yupu's presentation, I guess, there should be questions that Yupu would like to ask in today's session. So please, I want us to kind of take advantage of everything Miss Mercy has said. And also maybe if there are further informations we want to pick out right now, please, this is the opportunity for us to do so. So if we have questions in today's class or as regarding or as pertaining to this class, please, you can do well to raise your hands or indicate by sending your questions into the chat box if you do not want to speak, right? So can we have hands raised and questions asked? Do we have anyone with questions that they would like to ask in today's class? Please let us feel free to ask our questions. The session is designed to help you gather as much information and as much knowledge on the subject matter as possible. Okay, so Moyo Sola, please go ahead and ask your question.
Hello, good evening. So I have two questions. The first question is on consent, informed consent. So if the user has to read like a lot of complicated legal contracts in order to accept maybe some cookies on any site, is that considered informed? That's the first question. Then the second one is on sorry, I'm coming. I wrote it down here. How does the company? Okay. Then the second one is on the issue of the third party consent as well, like having a third party give consent to a form like next of kin and guarantors and all that. How does the organization know that the consent has been obtained, like from the person? Because most times when you are filling a form, they will just tell you that you should add your next of kings and you just add it. But you are not actually asking the person before informing the person before you added the person as next of king. So even if the organization has actually, or the company in this instance, has actually put the third party form, does that still justify it? Because to me, it is not informed.
Okay, thank you, Moyo. Remind me the first question, sorry.
Okay. So my first question is on informed consent as well, but this is on having complicated legal contracts on sites. Like
Okay,
when
yes, I remember now. Yeah.
yes. So
So
how is that considered informed?
I will respond from a data privacy practitioner point of view, right? In our practice, what we do is that we advise, and in fact, the NDPA says that your privacy policy should be clear, concise. That is, it should not be ambiguous, right? I also want to believe the GDPR has an equivalent provision for that. So typically, a privacy policy should not be. Keep in mind that T&Cs, terms and conditions, and privacy policy are not the same thing. Do you understand me? It's possible that privacy policy is embedded in the T&C, but typically, privacy policy should be a standalone, and it shouldn't be verbose. It shouldn't be lengthy, such that someone cannot read. In fact, some of the best privacy policies you will find are very short and straight to the point, but it gives the data subjects all the necessary information they need to know. What are my rights as a data subject? Is my data going to be transferred? What are you doing with my personal information? Who has access to it? What are my, I've mentioned that of rights, you get. Then the name of the data controller and their location. Do you see? So these basic things need to be found in a privacy policy, which is quite different from terms and conditions, and also cookie policy as well. If you notice, most cookie policies are very short. They just tell you these are the necessary active, choose the one you want and all of that. Right? It's not meant to be lengthy, it's meant to be concise. Per the provisions of the NDPA. So from a practitioner point of view, I emphasize, and when advising data controllers and processors, we advise that your privacy policy should be something your data subjects can read. The goal is not to put something they cannot read because you are trying to absorb yourself. So if something that happens, you can say, oh, it's there in our privacy policy. No, that's not the goal. The goal is to put something that people can read, understand, and then exercise their rights. So from your privacy policy, people should be able to know that if they want to modify their personal information, this is how they should do it. They can reach out to social email. Do you understand? They can take social steps. They even need to know that they have that right. So a data privacy in practice is not meant to be lengthy the way you've described. It's not meant to be verbose. It's not a terms and conditions. Usually terms and conditions encompass several other things. For example, if you have an app that is a payment platform, is an e-commerce platform, you buy goods, the goods are delivered to you, you make payment, the goods are delivered to you in this also time. If the goods are not quality, you send it back, this kind of thing, this kind of arrangement. A terms and condition will detail all of that. What should happen if you don't make payment, your order cannot be processed. If you make payment and it's not delivered within 3 days, make a complaint. But if you make a complaint, wait 24 hours. If it's delivered to you and it's not in good condition, return it. This is a return policy, no refunds, this one, that one, that one. It details a lot of things. So that is quite different from a privacy policy. Privacy policy just deals basically with how the organization, whether controller or processor, handles the personal information of a data subject. Do you understand? So to answer your question, I would say no. It is not good for a policy to be, let me just use the word outrageous, in the sense that someone cannot read and understand it clearly. Do you understand? I can't say, oh, it should be something you read within 10 minutes, because different people have different reading speeds, but it should be concise. On the face of people should look at, even from the headings, people should look at it and see, okay, these are what the privacy policy is addressing. Right. I hope I've answered this question. Then answer the second one. Yes, when it comes to that, third party consent, the company cannot vouch, so to say, that the consent has properly been obtained from the third party, but it is a way to first of all pass the message that we have this person we are obtaining this consent from, the person we're obtaining the information from, we've asked them to obtain the consent, right? So because we cannot, without this middleman, there's no business between the data controller or processor and the third party. Do you understand? If someone was not providing your information as next of kin, then there's no business for that organization to be having it. Do you see? So the reason why they have to collect such information is because of this person they are collecting from, right? So in essence, they are trying to say, we've requested for this person to obtain your consent, and we are working on the belief, on the strong assumption that your consent has been properly obtained, because really it is impracticable. In fact, the truth is, if you want to obtain next of kin consent, if you look at it in practice, you will see that you would have violated something already. You would have collected the personal information first before you even reach out to obtain consent. I don't know if that makes sense. For example, if you want to now obtain consent of next of kin, maybe you will need their name and phone number or email address to send a request and say, this person has provided your information, or kindly provide us with your consent. So you will see that processing has already gone on before that before you even obtain consent, which is not what the law intends. Do you see? So in essence, we are asking, this person intends to provide a third party information to us. Please give us your consent that this person, give us your confirmation that the person whose information you're providing has given consent for the information to be processed by us. That's the safest they can do. Because without them having that information, they can't reach out to the third party or the next of kin, the referee or the guarantor, to request their consent. What you would then want to do would be to say, oh, after you've now obtained the information, it depends in practice, depending on how a company chooses to operate. You can then reach out to the third party to say, we have obtained your personal information from so person as either a guarantor or a referee. Some for example, you're applying for masters, you need to provide referee information. And the school you're applying to, most of the time, will reach out to the person you have provided as referee to say, oh, this person has given us your information as referee, you get it here. But for best practices, you as the data control officer, so you now want to maybe reach out to the data subject to say, so person has provided your information as a next of kin, a guarantor or a referee. Kindly confirm that you provided, and okay, you can say ahead that they provided your information and confirmed that they obtained your consent. Kindly confirm that we can maintain your information in our records. Do you see here where the person now gives explicit consent that or revokes consent to say, well, I didn't give consent in the first place, so please delete my information. You as the control officer, so you take the necessary steps. Do you see? And inform the person that provided information that, see, oh, this next of kin has said they don't want to do again. They don't want us to maintain their information. On the basis of that, we are deleting. You see, so there has to be transparency. Even if you intend to reach out to the next of kin or the third party, you need to let the person providing that info, the third party information, you need to let that person know that you'll be taking such steps. You see, that is why data privacy is transparent all the way. We identified that last week. There is transparency is one of the principles of data processing. It's transparency, accountability. So you're not trying to go behind the person who provided the information and go and confirm from the next of kin or the third party whether their consent was accurately obtained. You see. So you're collecting from this person, you're letting this person know that, oh, I'm going to reach out to the next of kin or this third party to let them know that we've obtained their information and that you obtained their consent, and just confirm that we can maintain their records. And when you do so, you're documenting all of the communications happening on both sides. You see. So yes, to answer your question, the company cannot vouch as to say or stamp or to swear, so to say that the consent was properly obtained. But it is the safest means or the safest route that they can use to absolve themselves of liability should any issues come up. Please let me know if I've answered both your questions. Thank you. All right. Thank you, Moya. I've seen your chat.
All right. Thank you very much, Ma, for helping us answer that question. Do we still have more questions for Miss Okay? Orogene, please, you can go ahead and ask your question.
Good evening, Ma. Can you hear me?
Yes, I can. Good evening.
Okay, so my question is about cross-border transfer of data.
Yes, please. Yeah.
I want to know, is it implemented? Because I know some organizations are transnational. So when you're like in relating with an organization, let's say you're buying products or you're subscribing to a newsletter, or like most of these organizations like online, it's not even within Nigeria, or some of them have they share their transnational. So when you see their privacy policy and you click on agree and all of that, with the NDPST apply to those organizations in quote, because the NDPS says as a general rule, cross-border is prohibited except so and so, like except the country has its own data protection laws and all of that. But in scenarios when you are subscribing or you are following a website and they ask you subscribe and you agree, you have already agreed to share your data. So in that place, is it like dealing with this kind of organizations, is it possible to implement this cross-border the provision that they must have complied also with data protection laws before they can have access to your data. I
Okay,
don't know if my
yes.
question is clear.
Yes, I understand. So what I see is that you're asking question from two ends. You're asking question from your end as the data subject as to, oh, if I'm now subscribing to an organization, what should I be looking out for? That's the way I'm interpreting your question. Then from the NDPC standpoint, are they able to enforce the NDP against such organizations that are multinationals, right? I'll answer from both perspectives, starting with the NDPC. Yes. Where an organization, whether multinational, national, non-national at all, they are just abroad, and they're processing personal. Once you're processing personal information of Nigerians, you are required to of people in Nigeria, you are required to abide by the provisions of the NDPA. Do you understand that? That needs to be very clear. Your Google, your Facebook, your TikTok, they are all required to comply with the provisions of the NDPA. Do you understand that? Multinational companies, you might have maybe your mention one multinational, your Reckitt, your why are they looping me? Your Nokia, your Samsung, all those ones that have cross international reach, right? Hey, for example, Samsung, your phone or your iPhone, they have all of your information. You're in Nigeria, they are required to abide by the NDPA. In fact, some of these organizations, what they do is they have privacy policy tailored according to jurisdiction. So for people in Africa, for people in Nigeria, once you're signing up, you get the privacy policy you're going to receive is the one that applies to you as a Nigerian. Do you get? What you would then also now, from the NDPC standpoint, I hope I've answered that. Yes, they can enforce the NDPA. That's a given. Now, from your standpoint as a data subject, what you're looking out for is, by the time you're now signing up, because you are now aware of what the NDPA provides, that this country needs to have an adequate privacy law, you want to check where is the headquarters of this country, or where are their branches. These branches, do they have data protection law? The countries in the US, the UK, these ones now, the US has its own data protection laws. The UK, under I think GDPR, you get it. You want to check, is this country under the GDPR? Where it is not, do they have their own data protection laws? If for example, the US, the different states have their own different data protection laws. So you want to see if it's in California, what are their data protection provisions? Do you see? That's what you then want to confirm for your own protection as a data subject. And then if there's any issue and you feel, oh, this organization is not abiding by provisions of the NDPA, then you want to report that to the NDPC, which the NDPC will now investigate to see where the problem is coming from and take the appropriate action. Do you see? So yes, I hope that answers your question.
Yes, indeed. Thank you very much, Ma.
You're
Then
welcome.
another question I hope I'm
Okay.
free to ask
Yes, please.
is, I just wanted to know, are there like international, should I call it laws or general provisions that apply such that these multinational companies, so long as they're in compliance with that, they are safe in dealing with data subjects across the
So
world?
far that I know, data protection laws so far are still territorial, right? But for example, the GDPR that applies to European countries, Africa is still working on a network. There's this network of African data protection authorities, right? Africa is still working on harmonizing its data protection laws such that, maybe if a company, if an organization complies with that African harmonized law, then it would then substantially be complying with all of the individual countries' requirements. Do you see? So Africa is still there are ongoing conversations about harmonizing the law in Africa, data protection laws in Africa. It's an ongoing conversation, but so far in Africa, it's territorial, right? But for the GDPR that applies to European countries generally, that's one international law that you can see applies. You see, but so far it's just like your IP laws. Usually they are territorial for now, that I can see. But I know that there are ongoing conversations about harmonizing laws internationally on international scales. For Africa, it's an ongoing conversation, right? I hope that responds to your question.
Yes, ma'am. Thank you, ma'am.
Thank you.
All right, so we can still take one question. So if there's still any last question that anyone wants to ask, we'll be taking that. If not, we'll be calling it an end to class. So please, do we still have any last question? Okay. I guess we don't have any more questions. I want to say a very big thank you to Mrs. Mercy for the last 2 weeks, right? Both week 1 and week 2. You have helped us done very good justice to our subject matter. You have been patient with us to answer our questions, and have also shared your thoughts very explicitly, trying to break down concepts to the barest minimum for us to understand. And for that, we want to say a big thank you for joining us in both sessions and sharing your thoughts and knowledge. And also, let me to add wisdom with us within that sense. So, thank you so much, Ma, for everything that you've done for us. We really sincerely do appreciate. I don't know if we
Thank
have
you so
mentees,
much.
and can go ahead and share your emojis and just as a show of appreciation, Mrs. Mercy. Thank you so much, Ma.
Thank you
So
so
with that.
much.
So with that, we've come to the end of today's session. It has been a wonderful day in class. Please, for the mentees, do well to share what you have learned on your social media platforms. Also, do not forget to tag our mentors, and also do not forget to fill in your attendance. Let's all try as much as possible to ensure that, for class, we are always on time, right? So that, we don't get to miss out on anything that is said within the class, because so much information from start to finish is being divulged. So thank you, everyone, and please enjoy the rest of your evening. Good night, everyone.
Bye for now, everyone.